You practiced in Van Nuys for many years, and you probably recall something that happened. I'm going to say it was in the 70s. It might have been in the early 80s. A judge was hearing a case in Van Nuys court, and the father threatened that if the judge was to award the mother custody of the child, he would kill both of them. And the judge went ahead and made the order of custody of the child to the mother, and the father indeed kept his promise. And it was in the papers, and the judge was devastated. But we really saw that judge impacted after that horrible event. He just never was able to make decisions after that. I mean, he had a great difficulty. What resources, I'm sure times have changed and circumstances have changed, what resources are there for judges who live these lives where events occur that have such a tremendous trauma on the judges as well?
Well, of course, we have a much broader understanding about not only the existence of domestic violence, but the risk of lethality. And that's probably the most important thing. I liken it to criminal law. You know, if frequently a judge will decide, for instance, that a criminal defendant should go on probation, and then they go out and commit another crime. No judge is going to wake up in the morning and go, you know, I'm in the mood to let some people out today so they can go commit more crimes. No more so than any judge would wake up in the morning and have the mindset that I think I'll award custody so that somebody can get hurt or killed, or I'll grant or deny a restraining order so that some bad thing can happen. The truth is that as we make decisions, people act out outside of our courtroom in ways that, of course, we don't support. Of course, we would never make a decision anticipating that. And we've certainly seen some recent examples. I think higher level of sensitivity to the issues related to domestic violence are not only part of training, and that's, I think, the biggest thing that's changed since the early 70s. Now for judges, our state, California, puts a lot of resources into making sure that their judges are well trained. And so not only is there a new judge orientation for a new judge, not only is there a 2-week judges college for a new judge, but there is, as of late, what are called primary assignment trainings that are usually a week or more in duration. And fortunately in Los Angeles County, we have 2 days a year where the judges just all go away and we focus on learning and adapting our understanding. So I think training is probably the number one additional thing that exists today that didn't exist in the 70s. And then, of course, social understanding of risk of domestic violence is something that we're all still learning more and more about. When I first started practicing, and I'm sure it was true for you too, Ron, the idea that domestic violence existed was kind of only reserved if somebody got arrested. Whereas, of course, we know that domestic violence is on a spectrum of lethality, where there can be various kinds of domestic violence that can be emotional and physical, and we're learning more and more about that. I think probably the best writer in this area, if somebody wanted to read about the understanding of how domestic violence interplays in the family law arena, is Dr. Jan Johnston, and her book, In the Name of the Child, second edition, particularly chapter 11, talks a great deal about making appropriate levels of analysis of the interplay of domestic violence in the family law area. It's a big problem, there's no question about it. And the news is filled with really tragic and horrible examples where children are killed. We had a case last year down in Orange County where a mother, because she didn't like what was happening in a family law decision, either she or the grandmother killed 2 precious little girls. We had a case in the southern part of Ventura County 2 years ago where a dad reached a stage of hopelessness and took his life and killed the kids as well. No judge ever wakes up in the morning unaware of the huge responsibility of every decision.
Thank you, Tom. We'll be back more with Honorable Judge Tom Lewis, and we'll be back right after this.
Ron and Robert on Divorce is designed for information and entertainment purposes only. No attorney-client relationship is formed or intended. Attorneys Ron Supancic and Robert Borsky suggest you seek professional legal advice for your specific legal issues. This program is brought to you by the Law Collaborative, LLP, a California limited partnership registered with the State Bar of California.
We're back with the Honorable Judge Thomas Trent Lewis, Department 79, L.A. Superior Court.
And this conversation has taken a very serious turn in that Judge Lewis has been talking about some of the weighty decisions that have to be made by judges and the concerns that they have. After all, they're human beings with emotions, and they make decisions that affect lives and families and children, and sometimes the consequences can be very, very upsetting. So Tom, I'm curious. You practiced family law for 28 years. You were on both sides of the case, representing mothers, representing fathers. You brought to those cases a certain expectation with regard to the bench. Now you are the bench, and you're making those decisions. What have you learned in the 4 years or more that you've been sitting as a judicial officer that would be beneficial to lawyers that are bringing clients to family law courts?
Well, I would say the three things that I think a family law lawyer should be very careful to bring to the bench in terms of the representation of the client. Maybe there may be some dispute about this, so I'm just going to speak it openly. The first thing I wish I had done as a lawyer, let's try it that way. What do I wish I had done as a lawyer that I didn't do as good a job now that I'm on the bench? And the first is very simple, but I think it's profound, and that is actually answer the judge's question. Not just what you want to say, but actually be sure that if a judge asks you a question, they're asking it for a reason, and make sure that you give an answer. Now, the difficulty there is that you might have to acknowledge that the answer is not particularly favorable to your client. I think that the thing that the family law lawyer will often forget is that it's not just one client that your reputation is involved with. It's your reputation in front of a bench officer. The obligation to provide zealous representation, of course, is there. But misleading judges, unfortunately, I have seen that happen, not so much to me, but I've had colleagues contact me and say, I have a lawyer and they're arguing this particular point of the law. Is that actually the law? And have had to say, sadly, no, it is not the law. And so I guess the best way to say it is, what do you think the lawyers gossip the most about is the judges. Don't forget, the judges will talk about the lawyers. And building a reputation for candor, building a reputation for properly within the bounds of advocacy representing the client, but not misleading the judge, that's a huge issue. And it particularly is important with the issue that you described earlier, which is that, we have lots of folks that may not have a lot of background in family law assigned to that area. So I've seen cases where somebody urged, for instance, just by way of a simple example, that there should be an order for spousal support, alimony in some jurisdictions, in a paternity case or a parentage case. Well, of course, we all know that if it's a straight paternity case, it's probably a non-marital relationship, and alimony or spousal support is not appropriate. But using the guideline calculators that we have, the judge doesn't block the alimony, makes the order, and the recipient of it doesn't stand up and actually say to the judge, Your Honor, you don't have jurisdiction to order alimony in this case. And I've actually seen that happen. And, of course, the consequences end up being that you can't buy back that reputation, when you make such a horrendous misstatement of the law to a judge. That's going to be a very costly decision. So answering the question, answering it honestly in a forthright way, but still representing the client, I think those are really important considerations. And then being sure that I would say being sure that you're providing at least a brief memorandum of points and authorities to the newer judicial officer if you're fairly sure that they don't know what the law is. Making and I'm going to stress the word brief statement in a memorandum of points and authorities about what the law is in a particular area. If you need to educate your judge, Justice Donald King, a name that I know is revered throughout the state and certainly beyond the borders of California, has said in several courses that I've taught with him, that which may seem simple but is, I think, deeply profound, and that is know your judge. And so knowing what the particular style and orientation of a particular bench officer is, I think, very important.
Thank you, Tom. And that's going to end it for this version of Ron and Robert on Divorce. We'll be back with much more from the Honorable Thomas Trent Lewis in more of our shows. Thank you so much, Tom. We'll talk to you on the next show. And for Ron and Robert on Divorce, have yourself a great week. Thank you for listening to Ron and Robert on Divorce with California attorneys Ronald Supancic and Robert Borsky, partners in the Law Collaborative Los Angeles. Join us again next week for more California family law with unique and insightful discussion and interviews on all aspects of California family law. With offices in Woodland Hills and Beverly Hills, California, the Law Collaborative Los Angeles, experts in collaborative law and mediation, excellence in litigation.